To the McKinney Tea Party, Michael Massengale.
Thank you very much.
Thanks for coming back to see us again this evening.
Glad to be here.
Have a seat. So you are a candidate for which position?
Texas Supreme Court, place 3.
And your current position is?
I'm a judge on the First Court of Appeals in Houston. It's a 10-county jurisdiction. And I've been there on that court for 6.5 years, originally appointed by Governor Perry and elected twice.
And that court hears what type cases primarily?
So it's an intermediate appellate court in the state court system. We get appeals from the trial courts. It has both civil and criminal jurisdiction. Statistically, it's about half and half in my court between the civil cases and the criminal cases. The only kinds of cases in the state court system that we don't see are death penalty appeals, because those go straight to the Court of Criminal Appeals in Austin.
Are there cases that would go to the Supreme Court that would not have come through a court like yours? And I guess the indirect question behind that is, have you at the level at which you're working currently pretty much seen every type of case that you would be seeing were you to be elected to the Supreme Court?
Yes. Generally speaking, it is possible for a case to skip over us, but it's rare. Most cases that go to the Supreme Court are appeals, and by appeals, it is exactly what you would imagine. There's been a case in a trial court, and then after a decision that somebody is challenging, it works up through the system, usually first at my level at the Court of Appeals. And then a major difference is that at the Court of Appeals, we generally do not have any discretion. If the case has been properly appealed, we have to decide it. But to get beyond my court, the Supreme Court or the Court of Criminal Appeals for criminal cases, those courts have discretion about which cases to take, and they are choosing cases based on their importance, based on a variety of factors. And the one exception is that in some circumstances, something called an original proceeding, usually a writ of mandamus, can be filed directly in the Supreme Court, and those are generally very unique circumstances, either to compel the action of a state official to perform a duty under law, or if something requires very, very fast action, there are rare circumstances where something can be filed directly in the Supreme Court.
So I would assume that you would see your past and current work experience as good preparation for the position you're seeking.
Absolutely. And I think the fact that I've served for 6.5 years on the Court of Appeals really helps me with that part of the job where the Supreme Court judges are deciding which cases to take. I have a strong sense of the kinds of legal issues that are percolating, things that there are conflicting authorities around the state, statutes that have problems where we see on a repeat basis problems coming out of the trial courts, difficult provisions where there are consistently questions arising. Because I have that perspective on the Court of Appeals, at the Supreme Court I will have perspective about what kinds of cases that court needs to be taking to resolve conflicts and provide guidance to the courts around the state. I also want to add, before I became a judge, I was a partner at a large firm, Baker Botts in Houston, where I practiced a wide range of civil litigation. So I also, in my particular race, I have a much broader range of experience that's relevant to the court. The business community in Texas, we're very proud that people are coming to Texas because of our business-friendly climate, and a big part of that is people having confidence that the courts will enforce the rule of law, will decide cases efficiently, and the fact that I have that experience with business litigation will be very helpful in that court. Just today, there was a very important case decided in the Texas Supreme Court involving an area of law called fraudulent transfers. And when I was a partner at Baker Botts, I worked on the case that resulted in the largest judgment in any fraudulent transfer case in history, I represented a company that had been defrauded by a Mexican industrial conglomerate, and we obtained a $7 billion judgment in federal court with a fraudulent transfer claim. So I've got highly relevant experience for the court.
Good. Let me jump to a kind of a hot topic. You're in the Supreme Court. See if you make it to that position in a state not too far away, Alabama. One of their Supreme Court justices has told the United States Supreme Court, "You're wrong. You have issued an order that we disagree with, that we do not think the federal government has the right to issue an opinion on," and he subsequently ordered his area district courts not to abide by that. Tell me your thoughts about that, and I'll give you the preview follow-up question. Where would you draw the line? Because I could think that if you look at some recent Supreme Court appointees, primarily by Democratic presidents, but not entirely, unfortunately, there are some legitimate reasons to worry that if the Supreme Court shifts one more position, we're going to have some 5-4 decisions that are going to go 4-5 in ways that most of this audience is not going to be happy with. And one of the things that we're looking for is, at what point do you draw the line and say, no more?
Sure. There are a couple of facets of this. First of all, with respect to what Chief Justice Roy Moore has done in Alabama, and some of this is pretty new. I haven't had a chance to really study it closely because I've been working pretty hard on this campaign. But I do think there's a little bit of misperception about what he's done, because what he's done that's gotten a lot of attention, he did in his capacity as Chief Justice, where he has some administrative authority over the lower courts in providing guidance to how they should be handling controversies while some other matters are being decided by the court. So it is a little bit of a technicality, but to answer your question, I think that the Texas Supreme Court is a very unique, by being the court that's at the pinnacle of our state judiciary, it is a unique opportunity for those judges to speak on our behalf and push back against wrong authorities that have come out of the U.S. Supreme Court. Now, when I say that, I'm not suggesting that I think the Texas Supreme Court should defy precedents of the United States Supreme Court.
Under no circumstances.
Well, let me explain. See, there are certainly opinions out of the U.S. Supreme Court that I disagree with and I think are inconsistent with the Constitution. But if we go down the road, and I'm talking specifically about the judiciary, I think there may be other answers or a broader range of options open to other branches of government. But within the judiciary, it is a dangerous path if we as judges start picking and choosing which authorities we're going to respect out of the United States Supreme Court. And so on an interpretation of the U.S. Supreme Court, I think judges, because the U.S. Supreme Court does have the authority on questions of federal law to review decisions of coming out of the state system. And so if within our state system, we just decide we're going to pick and choose which authorities we're going to follow, that's sort of a recipe for anarchy within the judicial system. Okay? All of that said, there is still the opportunity for the courts to talk about how the U.S. Supreme Court is getting things wrong, which creates opportunities for new cases to come to the Supreme Court and issues to be reconsidered and reevaluated. And I have an example that's very recent and very salient. In the area of the United States Supreme Court's abortion jurisprudence, it's a total mess, and there was a recent decision just in the last year coming out of the 8th Circuit Court of Appeals. There was a constitutional challenge to some abortion restrictions that were passed in South Dakota. Now, that challenge worked its way up to to the Court of Appeals, the Federal Court of Appeals, and the abortion restriction had been invalidated by the federal court, saying, applying the existing abortion jurisprudence of the U.S. Supreme Court. And accepting the authority of the Supreme Court, they had applied these cases, and lots of people would say the Supreme Court's gotten them wrong. The Court of Appeals said this was a correct application of what the U.S. Supreme Court has done, but we implore the U.S. Supreme Court to take another look at this, and there are reasons for it. And one of the things they pointed out is that under the U.S. Supreme Court's abortion jurisprudence, we have the absolutely intolerable circumstance that the constitutionality of abortion restrictions is changing as our scientific understanding of what's happening in the womb, of a fetus's ability to survive outside the womb, as our understanding, our medical understanding improves, as our medical technology improves, the way the U.S. Supreme Court has structured its jurisprudence, the constitutionality of abortion restrictions changes as science changes, and that is totally inconsistent with the idea that the Constitution has a static meaning and the meaning that was intended when it was adopted. And so I point that out to say that a court can be both faithful to the authority of the U.S. Supreme Court, but also have faithfulness to the Constitution and point out problems that have been revealed with problematic decisions of the U.S. Supreme Court. And I think we need more of that in the Texas Supreme Court. We need a higher level of awareness of how bad U.S. Supreme Court opinions are restricting our ability to govern ourselves in Texas the way our founders intended for us to have a wide range of freedom to govern ourselves. And our court can be our soapbox, can say, well, the Supreme Court said we can't do this, but we think there's a problem with it, and we'd like to see these things reconsidered.
And is that something that you see yourself? I mean, as a candidate for this position, is that something? I mean, obviously, primarily as a judge, you hear cases and make rulings, but is that, if I may, I'll use my phrase, conservative activism, is that a goal of yours?
Sure. I wouldn't use those same words, but what I will say is I would like to be a leader on that court to look beyond the borders of Texas and have a stronger awareness of legal trends, both bad constitutional trends in the Supreme Court, but also other trends around the nation that threaten to affect us in Texas. And I think a perfect example of this is what happened with same-sex marriage. It was no surprise in the summer of 2015 when the United States Supreme Court did what it did. What I find very troubling is that this issue of whether the United States Constitution requires states to recognize same-sex marriages evolved through state Supreme Courts over 20 years. Okay? It started in the Supreme Court of Hawaii, a decision which is actually what prompted the passage of the Federal Defense of Marriage Act. And then if you read Justice Anthony Kennedy's opinion in the Obergefell case, he traces this history, and he talks about how it started in Hawaii. There were decisions out of state Supreme Courts in New Jersey and Massachusetts and Vermont and Iowa. And part of the point that Justice Kennedy made was the trend of these decisions across the country was uniformly to recognize a constitutional right for same-sex marriage. Part of his point was there were no state Supreme Court decisions going the other way. And my question is, why wasn't there? And why wasn't there one out of Texas? In my opinion, there should have been one out of Texas. We had the opportunity. Cases were filed in 2011. I think our court acted too slowly. They waited 2 years to even decide to accept the cases. And I think that in 2011, the writing was already on the wall that this was an important issue, that this case was on a bullet train to the Supreme Court. And I think the Supreme Court should have seen that as an opportunity. It should have been a priority to take those cases, to decide them on the merits of the constitutional issue. And so I view it as an enormous missed opportunity that there was never a merits decision out of the Texas Supreme Court that affirmed our right as Texans to enshrine in our state constitution a recognition of traditional marriage.
And I assume that court includes your opponent.
Well, my opponent is a unique case on this issue.
And I'll ask because we're running past time.
Yeah.
Just a short answer on that one.
Sure. Well, my opponent was the only member of the court who failed to sit on that case entirely, and I've raised this since I've gotten in this race in mid-2015, and she has consistently refused to give any kind of a plausible explanation for why she didn't sit on that case. It was the most important constitutional case to come to the Texas Supreme Court in decades, certainly the most important constitutional issue that my opponent has seen in her judicial career, and I think that failing to show up for work on that important case is a firing offense.
And I'll mention also in fairness here, we've tried with the previous races to have all the candidates for all the positions be able to give their position. We did invite your opponent to this forum here. Sent multiple calls, emails. Brian, our schedule, I know. I mean, the guy's a bulldog. If he wants somebody to come, he's going to get him to come. So your opponent's absence is not because of selection, a selective invitational process. The pursuit of all the candidates for this position was equally applied. Right. Thank you very much.
Oh, it's my pleasure, and I would really appreciate your support. Thanks for having me.